Okay, thank you. For those of you that weren't here bright and early this morning, I think most of you were, and I'm always amazed when we start off and have a crowd like this, and it's great to see such a good crowd and see this room filled up. I'm Randy May, president of the Free State Foundation. Now, I did remind all of you earlier to please tweet away. I've noticed there are quite a few tweets, and that's good. So the handle, it's on the front of your brochure. It's hashtag FSF CONF 11. I try to say conf, but that's doesn't work. Hashtag FSF CONF 11. So please do that. I have to say, I'll just say while everyone's now sitting down, I was looking at some of the tweets during that last panel, and I believe I saw this right. One of you tweeted something to this effect: for what it's worth, if I read those initials right, Randy May used to play basketball against Pete Maravich. I think I saw that on the tweets, unless I'm dreaming. Anyone here old enough to know Pete Maravich? You are? Okay. Well, thankfully the tweet didn't go on to say, that part is true. I did back in high school. I had to guard Pete Maravich, who I think was one of the greatest natural shooters that I've ever seen as a basketball player, but thankfully they didn't go on to say he regularly scored 25 or more points every time Randy May was guarding him. Okay, so welcome to this panel. We have really an all-star cast. That's why we call it an all-star panel, and we are going to focus heavily on I think some issues that the last panel didn't. I didn't necessarily mean for the division to be absolutely so stark that James Assey didn't even want to mention the word net neutrality, but he did. But there'll probably be plenty of net neutrality in this panel, or at least some. So I'm just going to introduce the panelists quickly. I'm not going to, as you know, do their full bios. Please look at the brochure. They're all so illustrious that would take up way too much time. I'm going to give you the one sentence, or at most two sentence versions. We'll just go right down the row here. Alden Abbott is General Counsel at the Federal Trade Commission. I'll just say that I've been fortunate to have Alden as a friend for a long time, long enough to know that over at the Federal Trade Commission, where he's held previous positions, he is considered one of the real institutional storehouses of knowledge about the things that the Federal Trade Commission does. Next to Alden, we have Kathleen Grillo. We're happy to welcome you back. I just point out on Kathy's bio, and I didn't notice this before, that Kathy was a law clerk to Judge Harold Green of the U.S. District Court. So are all of you old enough to remember who Judge Harold Green of the U.S. District Court? I know you are, but if not, he was the federal judge, of course, that oversaw the breakup of AT&T, the ramifications of which, of course, are still with us and always will be. So I didn't know that. Next to next to Kathy is Rob McDowell. Do I need to say anything else about Rob other than the fact that he is a fellow Dookie? I mean, I don't, you know, he's an former FCC commissioner. He's now with Cooley. By the way, Rob, when I was reading over the brochures, and I asked Laurie, my wife, to read them over as well to make sure we had everybody's name spelled right. And when she saw Cooley, she thought for sure there had to be something else. You know what? She said Cooley sounds like a rap singer or something. But anyway, Rob is representing Cooley and all former FCC commissioners in Duke University here today. And then, God, I hate to say last but not least, so that's okay, but we have Gigi Sohn. I'm delighted. Gigi is here today with us. Gigi has multiple titles. Now I'm going to use whatever came up first, but you'll have the other ones. Gigi's a distinguished fellow at the Georgetown Law Institute for Technology, Law, and Policy, and a Benton Senior Fellow and Public Advocate. So I'll just say, with respect to Gigi, that line, I mean, it's formalistic, or usually stated very formally this way, that Gigi and I may not necessarily agree on all issues. Sometimes there's that disclaimer. But the reality is, if I'm being truthful, I'd probably say that Gigi and I don't agree on most issues, to be honest. But that's really the point of why I wanted Gigi really to be here, because we always value a diversity of opinion in order to have really, I think, education, which is our purpose here. And Gigi probably has been participated, I should say, in as many Free State Foundation conferences and panels as anyone else that's not a part of the Free State Foundation. So,
I'm a glutton for punishment.
Well, welcome again. Okay, now, I'm going to start today's panel. This is really what I really want to do is have this discussion to be focused, to be different than the immediately preceding one in this way. For many years, this is our 11th annual conference, and for the most part, a lot of the discussion has focused more centrally, of course, on what we might call pure FCC issues, not exclusively, but broadly, and in that regard, focused more on what I'll call the internet service providers, rather than what I'm going to call the platform providers. Now, I understand, and most of you do here as well, that in today's world, there's a lot of convergence going on, and those terms, ISPs are not purely ISPs, in a lot of cases, and the platforms aren't purely platforms. But I'm using, during this session, when I talk about internet service providers, I'm talking about, for the most part, Verizon and companies like that, Comcast and so forth. When I'm talking about platforms, I have in mind the Googles, Facebooks, and Amazons, and so forth, because those platforms and the issues that we're going to discuss are right at the forefront today, of course, of topics relating to getting, it's not up there now, but getting law and policy right today in this internet ecosystem. Okay? Now, the way we're going to start, I've just asked the panelists to take 2 minutes if they would like. No one has to do anything they don't want to on this panel, but I've asked the panelists to take 2 minutes if they would like to speak to this question. In today's current communications and internet ecosystem, and some call it a dynamic marketplace, but you may agree or disagree, take 2 minutes to explain the macro principles or the mix of them that you think are most important as lodestars that should guide policymakers in, quote, getting the law and policy right from your individual perspective. And so when I refer to macro principles, I'm in my own mind, I'm thinking about what we call maybe first principles, but not necessarily at this point, the details of some policy. Now, so we'll just go down the line. I should have said at the beginning, but I'll say it, and it's probably obvious. Alden, as FTC General Counsel, and I mentioned his institutional knowledge, he's in somewhat of a different, position because he's here as FTC General Counsel. Well, we've got some different positions. And by the way, I asked Rob to be here. Rob is, like Gigi, been at many Free State Foundation conferences before, and I'm pleased he's here again. But I wanted Rob here to have some FCC institutional knowledge too, because of his tenure as FCC Commission. So with that said, let's go down the line for opening remarks if you have any.
Thanks very much, Randy. So let me, it's a very broad question, but let me, so to speak, stick to my knitting and tell you a little bit about the FTC and its role in the big picture. Now, the FTC is a very broad statute, Section 5, which allows it to take action against unfair or deceptive practices in or affecting interstate commerce, and unfair methods of competition in or affecting interstate commerce. Now, how does this apply to platforms or ISPs, particularly since the statute currently does not give the FTC authority over common carriers? Well, there was a decision, FTC v. AT&T Mobility, 2018, Ninth Circuit, that made it clear that the FTC has authority to protect consumers and to go after anti-competitive or consumer harmful behavior, say when internet service providers engage in non-common carriage behavior, even if they are inherently common carriers, such as cable services or video services. And also, of course, we have the Restoring Internet Freedom Order, which has added additional authority indirectly to the FTC by making it clear reclassification of broadband as an information service, not a common carrier service. So the FTC certainly, the point is the FTC certainly has authority in this space, and indeed, as I think I'll mention later, it has taken enforcement action, certainly in the consumer protection area, against AT&T and other ISPs.
Okay, stop, because that's your 2 minutes. That's good. That was a good sort of start, but you save the rest because we are actually going to stick with this 2 minutes. Kathleen?
Thank you. Thanks, Randy. It's always great to be here. So macro principles, I was going to start, I think the last panel did a really good job at kind of centering us on where we are in the industry, at least with respect to broadband on 5G, talking about the promise and talking about how important it's been to make sure that we have the right policy in place. That, I think, is the reason that we are, where we're going to literally leapfrog the rest of the world and be the global leader on 5G. So macro principles, what can we take from this background? Obviously, we want to always focus regulation and policy on the consumer and what the consumer needs and wants. We want to make sure that we're protecting competition, making sure that we have an environment where companies are competing to provide the best services to consumers, and then also protecting innovation and making sure that companies can invest in their networks and innovate both at the broadband level and also the services that ride on top of the networks. I mean, I think what we've seen in the last 15 years has been really amazing in terms of the hundreds of billions of dollars of wealth and market cap that have arisen based on the environment that we have now.
Okay, thank you. That was very nice example of what I had in mind for macro principles. Commissioner McDowell.
Thank you, Randy. Great to be here. Thank you for having me back. It's always wonderful to see. I wore my Duke cufflinks and my Duke tie. I noticed we have a Duke professor in the audience, Michelle Connolly, our old friend, and even Gigi is wearing Duke blue today in honor of the Blue Devils. And and I know there's some others. Everyone here in Washington loves Duke, and that's one reason why tickets for Friday night's game is they're going for $9,000.
Oh my God.
So, Paul, you love Duke. You're wearing Duke blue. Look, I caught you. You really do. You love. That's media bias, right?
Okay, this is part of your 2 minutes.
Okay, I'm burning
so
my 2 minutes. So I incorporate by reference a lot of what Kathy said. We need public policy that incentivizes abundance. And let's make no mistake that the American internet ecosphere is the envy of the world. Let's keep it that way. Let's not over-engineer it. I do think there'll be more regulation in this space. We'll talk more about that in a few minutes. But let's make sure we incentivize investment, innovation. All of those things will promote competition, and all of those things will promote consumer welfare.
Good. Gigi.
So, hello, everybody. It's great to be here. Thanks, Randy, for inviting me back again after a short hiatus. It's great to see so many friends and so many frenemies. Dick Wiley's already given me the thumbs down, so I know I'm in. So I will take under 2 minutes. My lodestars are universally accessible, affordable, and open. So yes, I agree with my friend Rob McDowell, with whom I seem to have a debate every other day, that the internet ecosystem or ecosphere, whatever you want to call it in this country, is the best, and really will continue to grow and improve. But not everybody in this country is benefiting from it. So we need to make sure that all Americans have access to super fast and super competitive internet and affordable internet, and right now, broadband internet, and right now that is not the case, and we still have significant numbers of Americans, particularly in rural America, that don't have access to the broadband internet and therefore do not have access to the wonderful ecosystem that Rob just talked about. Open, what does open mean? It means user-controlled. That means no gatekeepers or minimal gatekeepers. And this is something that would apply not only to my broadband internet access friends, but also my friends in the edge community. And I would say, because I must say it, because I just spoke at an FTC hearing on broadband competition, that these are two values that, as much as I like the FTC and believe it should have a role in overseeing the broadband market, these are two things that it really doesn't have the statutory authority to promote.
Okay. Thank you. So now we're going to delve in more deeply. And, I'll just say up front, there's sort of two sets of issues we're going to talk about. And at the end, if we have time, we can come back and talk about also 5G and some other things that are going on. But I want to talk about net neutrality first. We said it for those of you, again, who weren't here earlier. I mentioned this is our 11th conference, of course. At each one of the 11 conferences, we've actually talked about net neutrality, and we said a prayer right earlier that there may come a day when we don't have to talk about it in the same way, but we'll see about that. But we're going to talk about it today. So I'm going to start out with an easy question, and just we're going to take this a step at a time. So I want the panelists to adhere to that. Here's the question. Does everyone agree that it would be good for the country and for the internet if Congress could enact a law to resolve the decades-old net neutrality controversy? Now, just assume for the purpose of this question that it would be a law that you found acceptable or that you could live with. Now, remember the late John Dingell? May he rest in peace. Remember him? Because I had the privilege of testifying a few times before him, and he would look down from his perch and he would say, I just want a yes or no answer. And when he said it, you understood he meant it. Now Randy May's saying it.
You know John Dingell.
Yes or no to that question, and then you'll have a chance to explain why. Do you agree it would be good if Congress could resolve this net neutrality issue by passing a law? Gigi, go ahead.
Yes.
I'm going to call you Big Randy. Yes.
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 Okay, what a cooperative panel. Maybe, is lunch ready back there? No. Not yet, okay. Now, I just clipped actually last night something I'm going to read to take us to the next step. I saw this in, I think, one of the trade publications, I'm not sure which one. Debate over net neutrality offers, quote, more heat than light, close quote. Barclays said in a Monday research note. I haven't actually read the research note. I'm just reading this report from the trade press. Quote, while net neutrality and related issues have evoked strong passion since the early 2000s, very little of the discussion has evolved despite significant technological and economic shifts. Reinstating the 2015 rules as proposed by House Democrats would be bad for 5G, Barclays said. Quote, net neutrality formulations as proposed in Congress are blunt tools to deal with the fast-changing technological landscape, the firm said. The entire premise of 5G is the ability to enable different network capabilities for different applications. So that Barclays report went into the 5G, but it's just, I think, is a way to introduce a question about now, what do you see as an acceptable compromise that you could live with, or what are the really bottom line, must-haves in order to be pleased with or accept a law by Congress? So I'll just start. Maybe we'll start with Gigi, and we're going to keep this we're going to have time to go back and forth, so we want to keep these answers relatively quick, but draw it out a little bit.
Yeah, I think my answer plays into very nicely why whoever wrote that Barclays note doesn't understand what the debate's about. It's not about no blocking, no throttling, no paid prioritization. It's about FCC authority to oversee the broadband market. That's where the fight is. Okay, if it was just about the 3 bright line rules, okay, and we can quibble about the general conduct standard, non-discrimination, what have you. If it was just over that, we'd be done. Okay, we're not done because this is about whether the FCC, which has overseen networks since 1934, should have any role overseeing access to the most important network of our time, period.
Rob.
Well, that made my answer a lot easier. So it's not about the basic principles of net neutrality as they've been advertised for years. It's about one agency having authority over another. So if that's the case, then what we need to do is look through history. And back to what I said in my opening remarks, which is the American internet ecosphere is the envy of the world and became that way because of light touch regulation, because we had in place competition and antitrust law, as well as common law in torts and contracts and other places. So you do have Section 5, which is very powerful, as the General Counsel of the FTC just told us. It is broad and it is deep, and it created the right framework. So if that's the case, the FTC, Federal Trade Commission, is the right agency because history has proven since the internet was privatized in the mid-1990s, and it worked so beautifully, that is what has worked.
Kathy.
So I think it's important to just get back to, I think obviously no blocking, no throttling, something about paid prioritization is important. And I guess what I would like to see is consensus around those issues. I think there is. I mean, we've been working on this issue for 15 years, which is hard sometimes for me to think about. But there's a lot more consensus, I think, than people realize because of the heat that Randy was talking about that Barclays was identifying. So there is consensus around those things. I think those are pretty important. I think consumers care about those things. I think what we've sort of lost in this debate a little bit is how things should be, is that Congress, as, you know, as members elected by people, Congress is what's supposed to set the policy on these kind of things, especially something as important as net neutrality. And if we could get consensus around key issues and get a bipartisan dialogue going on those issues, I think that would be great for consumers, and I think that would be a really important step forward for the industry and for the country.
Alden, what would you want to add at this point?
Nothing apart from the fact that the FTC has indicated, the chairman and the other commissioners, that they are happy to work with Congress on appropriate legislation which would affect, you know, our jurisdiction, our ability to act against, in particular, privacy problems, consumer protection problems that are of serious concern to consumer welfare.
Randy, can I just add something? Because there's something so elitist about that Barclays note. You know, more heat than light, you know, too much emphasis. I mean, how many comments were filed in the last FCC proceeding? How many legitimate ones? You know, even if you take away the ones that people have said not legitimate, it's something like 20 million. Okay, and 4 million were filed when I was at the FCC. People care about this stuff. And if I hear one more person say, well, they don't really know what net neutrality is, and I mean, again, these are your colleagues, these are the American people saying they care deeply about this. And there's a markup going on as we speak that I am not participating in because I like you so much, Randy. The American people care about this, and again, to emphasize, it's not just the bright line rules. They feel like their broadband prices are too high, there's not enough competition. Rural people feel screwed, and this is a bipartisan thing. I mean, if you look at polls on net neutrality, and not just on the bright line rules, okay, on whether the 2015 Open Internet Order should have been repealed, we're talking about numbers in the 80% and 85% percentile. So yes, I think the fight is how much authority should the FCC have? And again, I'm not against the FTC having authority. I think they should both. The FTC is an enforcer that enforces over a wide swath of the economy. The FCC is a sector-specific regulator. And let me just say one last thing, because I spoke at this wonderful hearing last week. And I don't want to diss the FTC or the staff, who did an excellent job, and my friend Tom Struble was on that panel. But the questions and Barron, Barron was back there too, I'm sorry, I didn't say, you snuck in from Paris and then you snuck out again, so. Oh, and Christopher's here, so they're all coming to see me speak.
Okay, if you're trying to recognize all of your friends here.
I'm not trying to run out the clock. What I'm trying to say is the questions that the staff asked about how they might figure out what discriminatory practices are and how do we bring technologists into the agency were so basic. I felt like we were trying to import the FCC onto the FTC. And my question is, why can't we have both?
Okay, well, you know, if getting you to participate on this panel and be here at this conference kept you away from the markup, then I'm glad that happened. I'm just kidding. Look, here's, I think, the next question to see whether we advance this discussion a little bit before we, leave it. I think there's a little more we can do. On the principles, it seems like to me there's sort of two sets of issues, at least, that are somewhat separate. Whether there is an agreement or the extent to which there's an agreement on what the actual practices are that would be prohibited or otherwise dealt with in a piece of legislation, right? And we've talked about blocking and throttling and so forth. And then there's the separate question of really whether, if we're being straightforward about it, I don't think anyone's actually mentioned Title II or said it in those terms, but that's what the gentlemen on the Hill today, I think, are marking up a bill that, as I understand it, would restore Title II, which was at central to the Wheeler Commission's order. So my question is, You know, and it's really helpful to be as specific as you can be. I always have this dream that we're going to resolve the issue right here every year when we have this discussion. Let me ask you, is there agreement on the specific practices that should be prohibited in any legislation? And then is having or not having Title II a key part of your bottom line? Can you want to deal with that? Kathleen, you want to deal with that?
So I don't really like to think about it in terms of a bottom line because I'd rather talk about how we get to the ultimate solution. So how do we get Congress to address this issue outright? And I think if you did that, I mean, the whole reason we talk about Title II is because there's been a search for where the legal authority for certain net neutrality rules lies, right? And we've been back and forth in the courts for years over exactly that issue. If Congress speaks to the issue directly, and there's specifics about what the rules should be and what principles there should be, then you don't have to think about Title II or Title I. You're going to have a baseline foundational authority that will not be subject to court challenge and will be in place for good. And so that's kind of how I think about it when I think about what we need to do about net neutrality. And when I say there's consensus, I think there's a general view about at least the middle ground. I take Gigi's point that it goes beyond that. I wasn't trying to minimize. This is obviously a very complex issue, and I agree with her, an issue that's important to consumers as well, important to a lot of people. But you have to do that kind of hard work, and Congress can do that kind of hard work where we really work to try to find that place that's going to work for industry, that's going to promote investment and innovation, and then just put that in place.
Okay, Rob?
So real quick, so first of all, I should have said at the outset, I'm not speaking on behalf of any client of Cooley, just in my own personal capacity. So Gigi said something interesting too, which is broadband prices are too high, which they're not. I dispute that from the outset. The ARPU is cascading and has been for a long time, but whatever. What that actually shows is why are proponents of more regulation so focused on Title II at this stage. And keep in mind that this debate has evolved tremendously. Their position has evolved over the past 15 years. From there being a unanimous bipartisan consensus that Title II should not be imposed upon internet service providers. That was Clinton-Gore administration policy. That was actually FCC policy on a bipartisan unanimous basis through 2007. I was there for those votes and celebrated the unanimity of that, number one. So something changed between then and now. And won't go into motivations necessarily, other than are these attempts at sort of regulatory arbitrage. With the bill that's being marked up today, it still has its roots in Title II. It's a Title II bill. It draws its authority from sections 201 and 202, which are the heart, brain, and muscle of Title II. Everything else flows from 201 and 202, right? So that includes economic regulation, rate regulation. And if it's things like zero rating or you can't give away your product for free, which by the way, never once has the FCC told a common carrier they couldn't give away their product for free, so long as you treat all similarly situated end user consumers the same. But that is a new concept in the net neutrality debate, to the point where a company like Facebook, when we go to India, could not give away internet access for free to the poorest of the poor, tended to by Mother Teresa, right? So that was considered a violation of net neutrality. Talk about elitism. So what we can have a consensus on, if the goalposts would stop moving, is probably something akin to the 2010 FCC order. And that included the fundamental principles laid out by Chairman Michael Powell in 2005. So full disclosure, for those who don't remember, I dissented against the 2010 order because I don't think it was necessary. But this sort of Damocles and these changing goalposts have created tremendous uncertainty for everyone in the internet ecosphere, including having the general public believe that the Pi Commission's repeal of the Title II order would cause the end of the internet. I keep saved a photograph of CNN's headline for that day with a picture of my friend, Ajit Pai, in front of the seal of my agency saying, "The end of the internet as we know it." All right, which helped generate an atmosphere that caused death threats against his children, and there is someone serving time in federal prison for that. All right, so
Okay.
let's not just talk about elitism. Let's just not talk about the other aspects of this. This is a much bigger debate. We do need congressional legislation. You have this sweet spot in the history of internet regulation where you could have a codification on an overwhelmingly bipartisan basis in Congress, by Congress. You could get 60 votes in the Senate if you look at the fundamental principles of the 2010 order. But the proponents of today's markup don't want that. That's because that's not what they really want.
Okay, Gigi, I want to give you a minute or two, just if you want
Okay,
to.
because there was about 15 things in there, so let me
this
start
is gonna
very
be-
quickly.
Hang on just a minute,
Yeah.
yeah, but you got to do it, because I've got to get to the other stuff too. Take about 2 minutes if you want
Okay,
to,
yes,
and
okay.
wrap up.
What has changed since 2007 is 3 court cases. All right, when I was at Public Knowledge, we supported the net neutrality rules under Title I, but the court said, no, you can't have strong non-discrimination rules under Title I. Okay, people keep quoting back something I said in 2007 about it not needing to be Title II. But there's been a lot of water and 3 court cases. Now we're in our 4th court case under the bridge. That is what has changed. Okay, and until Congress acts, that's not going to change. Okay, that's the problem. I also will say that the median price for a broadband connection is $80 a month. Okay, for us, maybe that's not high prices, but for people in rural America and low-income America, that's a lot of money. There was so much there. So let me just say, let me just address.
Just say one more thing. if you
Okay, one other thing. The internet has not dried up and blown away since the I don't like to call it the Restoring Internet Freedom Order, I call it the Net Neutrality Repeal Order. Well, first of all, the repeal only went into effect about 7 months ago. Second, I would say there have been a couple things that should cause concern. It has nothing to do with no blocking, no throttling, no pay prioritization. It has everything to do with the lack of FCC authority. Okay, and that's, I'm sorry, Kathy, I gotta go there. Verizon throttling firefighters during the Mendocino fire, and that was not about whether or not the firefighters paid the right price, but they had nowhere to go. And I found it very telling that neither the FTC nor the FCC said, oh, if only the Santa Clara Fire Department had filed a complaint with us, we could have resolved it. Okay, that was a problem of authority. The second, and this is one that Verizon's not involved in, okay, the 3 carriers who sold geolocation information to data brokers who then turned around and sold it to bounty hunters. Okay, so if you're, let's say, an estranged wife, your estranged husband can find you and whatever, all right? That, again, is a lack of authority. It's a lack of oversight. And those are the problems, not necessarily the bright line rules. I know, I got to stop. One
You gotta
last thing
stop. No, you
about
gotta-
Title II. This is the most important thing, Randy, so please let me say it, okay? No, I'm going to say it last. And I'm not speaking for the entire public interest community. The reason the bill is in front of the markup right now is because it was the simplest way to take care of net neutrality. Simply restore the 2015 Open Internet Order, one where there's overwhelming support. But if you give the FCC strong authority under a different title, if you're down for that, Kathy, I think we can have a conversation. And then we can have a debate over the bounds of that authority.
Okay. Well, look, you know, I think the reality is, I talked about reality earlier, next year is the 12th Annual Free State Foundation Annual Telecom Policy Conference, and I'd be surprised if we're not talking about this again, and maybe we will resolve it then. But I'd be happy if we weren't, but we'll see. But now I really do want to move on. We're going to move to a different subject, and that's what I referred to earlier as platform accountability. When I talk about the platforms now, we're bringing them into this conversation along with the ISPs, okay? And we're going to talk about things like privacy protection, maybe social media harm, you know, these things that are in the news right now. Now, I want to say before I forget that none of the panelists are actually here, as far as I know, representing pure platforms like Google and Facebook. I did reach out to them. And at one point, you may have noticed if you read our emails, like I hope you do, that Malika Carroll, a senior official at the Internet Association, was scheduled to appear, but they basically withdrew and I couldn't get anyone else. So it's not for want of trying that I don't have a platform for this platform discussion we're going to have. So I'm just going to introduce it this way, and then we'll get into what, hopefully will be a educational discussion and civil, as always, here at the Free State Foundation. I'm going to just recite. Everybody knows about what's going on with privacy. It's in the headlines every day. And social media harms, that's potential social media harms. That's in the headlines every day. So you can just take that shorthand. I'm just going to go ahead and read off a series of questions that I think are, some of them may be statements that are intermingled, and then just open it up. And I think you'll know how to proceed from there. Okay. And these are some questions that come to mind. Should we rely more or less on the FTC to protect consumers from potential consumer harm from the practices of the platforms and the ISPs? The FCC, the states, do we need preemption of the states? And this is important. In what respects should platforms and ISPs be treated differently in getting law and policy right? Do the platforms and/or the ISPs have market power that justifies regulation or other government action to control their market power? If they have too much market power, in your view, do they need to be, quote, broken up, as Senator Warren has suggested? Should we rely more generally on antitrust law to protect consumers in today's environment? Do we need to reconsider, modify, repeal Section 230 of the Communications Act, which provides immunity for the platforms? They've been considered obviously different from publishers, and Section 230 is an important aspect of that. I just saw, I think just 2 days ago, and maybe he's been saying it all along, but Greg Walden, Congressman Walden, I think has been suggesting that there needs to be another look at Section 230 and others in Congress. I think Senator Graham here's another thing maybe you might have an interest in responding to. Just a few days ago, Senator Graham linked the idea of transparency with regard to the algorithms of, for example, Google and Facebook, and how those algorithms work, to requiring transparency with the ISPs, and drew some type of parallelism between those two. So those are things that I thought about in thinking about this issue of accountability for ISPs and platforms in today's environment. And again, I think what I'm going to do, because there's a lot there, is we'll go down the row. Alden, I'm going to let you respond afterwards from maybe the FTC's point of view, but I'll let Kathleen open it up. And just if you can limit your remarks to 2 or 3 minutes and deal with those issues, any of them you want to, and we'll go on from there.
Okay. So privacy, I'll talk a little bit about that. So Verizon has supported comprehensive privacy legislation since 2011. So this isn't something that we've decided we want to support in light of, the incidents and some of the scandals we've seen in the last few years. This is an important principle that we think is crucial for our consumers, and we're encouraged that there is a lot of focus on that right now in Congress. There is, unlike with net neutrality, there is a good bipartisan consensus, a group of senators that are thinking about these issues and looking at these issues, and hopefully will lead to consensus. I mean, it's a very complex issue, and there are a lot of things that have to get worked through. But we think that's really important for consumers, and it does have to be a national framework. We are concerned about the state laws that we're seeing popping up in different jurisdictions. And again, it's not necessarily about one state or what one state has adopted, but it's about the fact that we will have conflicting regimes in different states. And not only is that hard to comply with, it's confusing for consumers. I mean, your rights shouldn't depend on what state you live in. You should have those rights set at a national level. And there can be some state role in that. We've come out and said we would support state AG enforcement of a national framework. I think that is a good way to make sure that we have that federal-state dialogue that we've always had on some of these important issues. And so hopefully we won't, when we come back next year, we'll talk about a strong privacy law that was passed. But you do have to let me respond just one second to what Gigi said, and I don't want to get into back and forth on this, but I do think it's important just to clarify what Verizon's perspective is on the Santa Clara issue that she was referring to. That was not a net neutrality issue. That was a mistake that we made with one customer over a data plan that the customer had purchased. As soon as we realized what that issue was about, we apologized to the customer and we changed our policy. So the fact that I don't think it's fair to say that that has anything to do with net neutrality or that that was some, issue that we need to take in that context.
Okay, we're going to close out that issue, but that's fine.
I'm done.
I think I'm going to say, Rob, let Gigi go next, and then because you have the FCC institutional perspective, you follow Gigi. Go ahead, take 2 or 3 minutes.
Yeah, so I hope to work with Verizon on a comprehensive privacy bill, and I'm actually surprised that, there've been a bunch of privacy bills introduced in Congress, and none of them really quite get there. And this is actually one area where I think the rules should apply equally to both the platforms and the ISPs, and we've had agreements on that. On antitrust law doesn't work anymore. Particularly when you're looking at platforms, because antitrust, thank you to Judge Bork, focuses really on price and not on market structure and not on impact and democracy. And I think that's why companies like Google and Facebook and Amazon have been able to kind of grow unabated, because Amazon gives you stuff cheap and Google and Facebook are free. And I think there needs to be a serious look at antitrust law and fixing antitrust law. And actually, Senator Klobuchar has some very, I think, excellent bills that probably won't go anywhere, but I think they're very good conversation starters. I will say just generally, leave 230 alone. I will say that, because I'll tell you what, even though, talk about amending 230 is intended to freak out the large players, they actually have the resources to deal with some of the issues around reducing 230 or increasing 230 liability. It's the little players that are not going to be able to handle it. I just think that that's a conversation. We had Sesta Fosta. It's not great, probably does more harm than good, but I think we need to leave 230 alone. But that's not to say, I do think that the platforms, it's funny, I sometimes speak with some of the platform representatives, and they say, Gigi, we're heavily regulated, and I just have to laugh. And I think there does need to be more oversight, including, and this is where my friend Hal Singer and I join hands, on some sort of non-discrimination standard. It's not net neutrality, it's not the same thing, but it's some sort of standard that does not allow the platforms to favor their own content and services and applications.
Thank you, Gigi. Rob?
Thanks, Randy. So there was a lot there in your series of questions, and I'll try to move through them very quickly. So in no particular order, market power alone is not something that triggers a remedy, right? So is there harm to consumer welfare? Is there something wrong with the marketplace? So keep that in mind. I understand the Federal Trade Commission is undergoing a number of investigations of various aspects of the whole internet and tech economy. So maybe some reports will come out this summer or this fall, and those will be very interesting to read. But the term market power carries with it a lot of weight, but that alone doesn't really justify any action. And I'm not quite sure of the edge providers of how breakups would work. That's all case by case. There was a great column in the Wall Street Journal, was it 2 Mondays ago? I think Andy Kessler's column sort of flagging a number of questions regarding that, like what exactly is remedied when you start breaking it up. And so I want to caution my what I call big government conservative friends, and I see Barron in the back row. He's not one of those, small government guy, but which is, be careful what you wish for here. What's good for the goose is good for the gander going forward. We want to make sure that we keep the American internet marketplace the leader in the world. So let's be very careful before we weigh in with the federal government trying to manage marketplaces. Preemption, state preemption, however, I think is something that's absolutely necessary. We can't have this balkanized patchwork quilt throughout the country, whether you're an ISP or a platform provider or whatever. We will no longer be the world-leading internet economy if we have state after state come up with different rules for how things should operate. The internet is a global network of networks, and it really doesn't recognize borders. So that's interesting. And having said that, though, when it comes to privacy, by the way, throughout my 7 years as an FCC commissioner, I always pointed to the Federal Trade Commission to figure out privacy, because it was A, not our expertise, and B, really hard. So let them handle it. That's what they do. And so hats off to you. Good luck there, General Counsel Alden Abbott, who I imagine you were always first in your class with that name. I'm just guessing, unless there was a kid named, Aaron Aardvark in your class or something. But anyway, anyway, you always graduated first. But what's happening actually is the GDPR has become the global standard. As you go on your phone right now to your favorite website, you're opting into something that's probably the GDPR, and I don't think we can have that, especially with the right to be forgotten. And I think Gigi and I actually agree on that one. So be very careful. So I would love to see some modernized privacy legislation. I'll close by saying there are cultural differences when it comes to privacy from different countries, but there are also generational differences. So my kids have a very different view. I see Professor Conley nodding her head regarding her kids. My kids have a different view of privacy from what I do. But Europeans have a different view than we do. So how are we going to reconcile all that to where we have something that works? I don't know. Good luck, FTC.
Well, good luck.
All these comments are very impressive. And Alden, I'm going to get to you in a second. I think this was probably understood, but just to be really clear, when I asked those questions, I did it in order to provoke just this type of discussion. I didn't mean to suggest my answers, went one way or the other. So Alden, you comment on what you've heard the others say, and as it's relevant to, of course, the FTC as well.
And let me add in good bureaucratic fashion that my comments, represent my own views, not necessarily those of the commission or any individual commissioner. So now, as to privacy, I think it's already been mentioned that the FTC is interested in working on with Congress on appropriate privacy legislation. The FTC has a history of investigating privacy practices, including by platforms, and basically the idea on the consumer protection side is to make a promise to consumers, which a reasonable consumer understands as a promise, and you don't keep it up, that you violate that violates the FTC Act. And on antitrust, the FTC has some ongoing hearings on antitrust and consumer protection in the 21st century. And in particular, it is looking at the whole issue of a network effects, multi-sided platforms. How should exclusionary conduct, and Gigi Sohn mentioned that price is not the key necessarily, we understand that fully. How should exclusionary conduct by firms competing in these multi-sided platform markets, including predatory pricing, most favored nation clauses, vertical restraints, and so forth, which undermine rivals, how should they be assessed? So indeed, there's an understanding that where an ISP, either unilaterally or through contracts with third parties, excludes certain content, and this is under existing law, okay? We're looking at law for the future, but even under existing law, or an ISP would unilaterally or through contracts with third parties exclude certain content applications or services, we would engage in a fact-specific analysis under the antitrust rule of reason to see whether that foreclosure harmed competition by raising the costs of rivals or excluding competitors. So we are very attentive to that. And the bottom line of all this analysis, our lodestar, is consumer welfare. And I just should add, we don't have anything to say whether Title I, Title II, or anything. It is not our business to decide what the responsibilities of the FCC should be. That's entirely up to Congress. And we are not the FCC. We just follow our own statutory consumer welfare standard, but are happy to work with Congress on any and all appropriate legislation.
Okay, thank you, Alden. So here's what we're going to do now. I'm going to ask for questions in just a moment or two if we have any questions, especially from my friends in the press there. I mean, this is really a terrific discussion. I may have you guys, this very same people, back next year possibly, and I may try and get someone again from the Internet Association to be here, reissue that invitation. Now, in a moment after the questions, we're going to have lunch. Those doors are going to open right over to my left. And please get your lunch quickly and begin to eat it fairly quickly, because we want to move. We've really got the rest of the day is kind of jam-packed. We're going to have a great conversation with the academic advisors from the Free State Foundation, and then we're going to have a conversation with Commissioner O'Reilly, and then at 2 o'clock, Alden Abbott's boss, FTC Chairman Joe Simons, is going to deliver a closing keynote address, and we're going to get to all that. So,
Let's make sure we tell him Alden's doing a heck of a job today. Okay, that's good.
yeah, well, that is now on the record and on videotape. Does anyone, do any of you have questions? The mic is going to come up, and just for the record, identify yourself.
Hi, Ashley Gold. I'm with The Information. My question is for Mr. Abbott. Wondering if you could speak at all to the new task force that's going to be focused on antitrust in the tech platform sector, and if you could offer any more specifics on what you guys might be focusing on there.
Well, I think, well, thanks for mentioning that. The head of our Bureau of Competition, Bruce Hoffman, with the support of the Commission, of course, announced a task force, and is going to bring in some senior attorneys and with support of our many economists as well, who have an interest and background in tech policy, and it's going to look at a number of questions. So the idea is to focus particularly on platform markets and other markets that two-sided markets where you have a lot of attention being paid. And we will look at mergers, at sort of unilateral conduct, including contracts. And we're very aware, as I say, of concerns about acquisitions. Are they excluding innovation or slowing innovation? Are individual unilateral actions somehow excluding potential competition? All these issues. So the idea is just by focusing all of this in one place, we can make more efficient use of our resources and recognize that these are issues of continuing and growing area to consumer welfare. I'm not going to talk about specifics beyond that, but rest assured the task force is already busily working away, and we certainly anticipate good results from it.
Okay. If I have one more quick question, I will do it. Anyone have a question? If not, we're going to go to lunch right now. Please do it as quickly as you can, and please join me in thanking this outstanding group of panelists.